It's my job now to introduce to you our first speaker, and he needs a little introduction in this room. He is, as you know, a longtime friend of the Federalist Society. In fact, I think the first time I ever spoke to him was at a lunch, kind of like this, at a Federalist Society event. He spent most of his career in public interest litigation, and in that role, he became and has continued to be an advocate for state constitutional rights and advocacy under state constitutional clauses. Since 2016, he's been a justice on the Arizona Supreme Court, and given his just long devotion to state constitutional rights, we of course invited him to give the introduction here today. So please join me in welcoming Justice Clint Bolick.
Thank you so much, Corey, and I join in the accolades to the Federalist Society and particularly Colleen and Jennifer for really envisioning this and staying with it. Corey is absolutely right. My affiliation with the Federalist Society goes back to what I describe as the BP era, which was before pizza. And ever since introducing food and occasionally even wine to their events, the attendance has proliferated tremendously. But this is so gratifying that so many people care so much about our state constitution and originalism. I was so thrilled when Judge Perkins asked me to keynote this, and was very, very excited and honored, and she said, don't get too big of a head about it, though. You're really just the warm-up act for your colleagues. So I am really excited to see my colleagues who are speaking here today. In particular, if you've never heard Justice Lopez present his lecture on social justice, A Personal Odyssey, it's just incredible. You know, the entire room is just not going to be a dry eye, so I can't wait to see that again. So the subject matter today combines two of the Federalist Society's and my favorite isms, originalism and federalism. Originalism in the sense that judges are oath-bound to the Constitution. And I take that to mean that we are oath-bound to the words that the framers and the people agreed to. And we are oath-bound to give those words their original public meaning and to make sure that every word has its original meaning. And federalism, in the sense that, as my friend Jeff Sutton has written in his fantastic book, that we do not have one constitution, we have 51 constitutions. And we are fortunate that our constitutions in our states enjoy what I refer to as a freedom ratchet. We are empowered to give our constitutions a meaning that provides greater protection for individual liberty than is recognized at the federal level, but not less. And in many instances, our constitutions were designed to do exactly that. Every single state constitution has protections of individual liberty that are unknown to the national constitution, and every state constitution has provisions that provide greater constraints on government power than does the national constitution. When I speak on state constitutions in other states, as my clerks and interns who are in the room painfully know, I always love to look at those constitutions and find some nifty provisions in them so that I can then talk about those provisions that are of local interest, and they're incredible. Our Constitution is somewhat unique in the sense that it is one of the newest constitutions. There were already 47 state constitutions before ours, and so our framers had the opportunity to see what worked and what didn't work. Just to give you one of many examples, recognizing how many times the United States Supreme Court did not adequately enforce provisions in the federal Constitution, they provided a provision in our Declaration of Rights that says the protections in this Constitution are mandatory. Imagine that. You wouldn't think you would have to do such a thing, but based on experience, they recognize that would be a good thing to say. Our Constitution was a progressive era Constitution, and it was nonetheless at a time in the progressive era when progressives had a deep skepticism of government power, and especially the combination of private interests with government power, and a number of the provisions of our Constitution reflect that. I thought I would start out very briefly with some of the greatest hits of the Arizona Constitution from my perspective, and it's really, really tough to do that. Now, that's not to say that our Constitution is perfect, far from it. My colleagues and I recently issued a decision in a case interpreting the referendum power to say that that was an incredibly difficult decision because the wording was so imprecise and confusing is a dramatic understatement. But I would say, and I hope that people reading the majority opinion and the dissent in that case would agree that it's an example of two good faith originalist perspectives presented in both the majority decision and the dissenting opinion, and for that reason, I take institutional pride in that decision. So these are not always easy cases, but there are some provisions in the Constitution that are just amazing. One of my personal favorites is Article 4, Part 2, Section 13, the single subject rule, and it reads as follows: "Every act shall embrace but one subject, and matters properly connected therewith, which subject shall be expressed in the title." First time you read those words, I think probably almost everyone, except if you've worked in the legislature and you really understand what they're trying to get, has no idea what those words mean or why they would qualify to be in our state's organic law. One of my first cases as a lawyer defending the Milwaukee School Voucher Plan was challenged on precisely those grounds. It was actually the twin provision, which also appears in our Constitution, the private or local bill prohibition. And I, like probably the vast majority of people in this room, had never taken state constitutional law. And I had never looked at my own state constitution, much less the Wisconsin Constitution. And the program is challenged as a violation of the private or local bill clause because it was passed as part of the state budget. And over the course of 2 years of litigation, I began to research in great detail the reasoning for the single subject rule, the private or local bill rule, and it was my bête noire. Fighting this thing for 2 solid years, ultimately succeeding in the Wisconsin Supreme Court by the overwhelming vote of 4-3. And the oddest thing happened to me as I was combating this provision. I fell in love with it. Absolutely fell in love with it. I'm like, how brilliant is this? You cannot have more than one subject in a bill. Why? Because of the legislative practice known as log rolling, where you put a provision in a bill that would not pass on its own because people have to vote for the omnibus legislation, whether it's a big generic bill or more often the budget bill. And so I can't tell you how excited I was when we had a case very recently dealing with this subject, a single subject challenge to a number of substantive bills that were passed as part of the budget. And I am gratified that the court unanimously enforced that provision. And all I can say is I wish the United States Constitution had a single subject provision in it. Also, looking at the state constitution, it's remarkable to me. Sometimes I feel like the framers of the Arizona Constitution lived in the current time and transported themselves back to 1912 to try to avoid some of the difficult issues that the US Supreme Court has been dealing with. And this often comes to mind when I teach constitutional law at ASU. For example, in the area of gun rights, and I know Justice Lopez will be talking about that shortly, but what was the issue that was so vexing to the United States Supreme Court in the Heller case? Is there a right, an individual right, to keep and bear arms under the Second Amendment? And it's a difficult question because of the prefacing language in the Second Amendment that refers to militias. And it's a difficult issue, and I think in that decision too, you had two very strong, good originalist perspectives. Well, what does our Constitution have to say about that? And this was written in 1912. It reads as follows. This is Article 2, Section 26. The right of the individual citizen to bear arms in defense of himself or the state shall not be impaired. It's as if they anticipated not only that decision, but the more recent decision dealing with what are the purposes for which individuals can bear arms. Just absolutely remarkable. Again, one of my personal favorites involves eminent domain. All of you are familiar with the infamous Kelo versus City of New London case in which the United States Supreme Court interpreted the Fifth Amendment to hold that the public use provision really means public benefit, so that you can take property from one private property owner, transfer it to another private property owner, so long as it serves some public benefit. Wow, did our framers anticipate that? And again, in our Declaration of Rights, Article 2, Section 26. And fortunately, my colleagues and I, Section 17, fortunately, my colleagues and I at the Institute for Justice were able to litigate under the Arizona Constitution in the Bailey's Brake Service case that some of you may remember. And our provision reads as follows. Private property shall not be taken for private use. And at the end of that, and this would have completely obviated the Kelo decision, whenever an attempt is made to take private property for a use alleged to be public, the question whether the contemplated use be really public shall be a judicial question and determined as such without regard to any legislative assertion that the use is public. How profoundly different, and unsurprisingly, when that same question came to our Court of Appeals, the answer was different than it was in Kelo, and as a result, Arizonans enjoy greater protection of private property rights than many other citizens around the country. And finally, and this one is just very, very provocative to me, and this is similar to provisions in other states. Right now, the issue is coming up as to whether entities like Google and Facebook are public forums, whether the folks that own those platforms are subject to freedom of speech constraints. And I think, certainly under current precedent in the US Supreme Court, that the answer would be no, because that they are not state actors. Who knows what will happen when that issue actually does go forward. I know a number of notable scholars are arguing that they are quasi-state actors. Section 6 of our Declaration of Rights says, every person may freely speak, write, and publish on all subjects, being responsible for the abuse of that right. Notice anything missing there? There's no state action predicate. What does that mean? I have no idea what that means because we've never gotten a case on that subject. But it just illustrates what is in our state constitution. And these depths have never been plumbed because rarely are state constitutional issues presented to our courts. When they are presented, oftentimes they are not argued independent of the United States Constitution, and our own jurisprudence writ large is incredibly discordant with regard to when we independently enforce our state constitution, when we lockstep it with the US Constitution, and so it's understandable why litigators would not bring those cases to us in many instances. But when they do fail to do it, they often are leaving possible litigation theories on the table, which I think is not a wise thing to do. This all inspired me to write an article that is in your CLE materials, which was an ASU Law Review article called Principles of State Constitutional Interpretation. And the reason that I wrote it is that there is really not a single state Supreme Court anywhere in the country that has articulated these principles. The Washington Supreme Court has come about as close as possible. But basically, this was an effort to intertwine originalist jurisprudential theory with state constitutional interpretation. I have to add, you know, the old adage that if a tree falls in the forest and no one hears it, did it make a sound? This article, and I'm enormously proud that ASU Law Journal published it, but it wasn't until the Federalist Society republished the article that people actually started commenting on it and getting back to me with their thoughts. So I am very, very, very grateful to the Federalist Society for republishing it. So I'm going to very briefly go through the 5 principles of state constitutional interpretation that I outline in the article. The first has been an issue of great division on the Arizona Supreme Court over the years, and that is what I call the primacy principle. And that is, if a state constitutional issue is presented and a federal constitutional issue is presented, which do you examine first? Now, I say that the cases are inconsistent, but they have never joined the battle. Sometimes they say one thing, sometimes they say the other, but they never really explain why one approach is taken versus the other. But I believe very strongly in the primacy principle. Our state constitution was intended to be our primary bulwark for the protection of liberty. Remember, in 1912, when our Constitution was adopted, there was no incorporation of the Bill of Rights. If we had a constitutional objection to something that our state or local governments did, we had one recourse and one recourse only: the Arizona Constitution. The fact that there has been incorporation of most of the Bill of Rights against the states has provided a second protection that has eclipsed the first protection, so that state constitutional law is virtually an afterthought. And that is also a result of the New Deal, which eviscerated federalism in every respect, including state constitutionalism. But it was intended to be our primary bulwark. At the time our Constitution was adopted, the principal philosophy of judicial interpretation was originalism. That was a time when originalism was dominant, and then obviously that disappeared as well. But thanks to the Federalist Society and many people in this room and elsewhere, it is making quite a comeback. We take an oath to our state constitution as well as the federal constitution. Federal judges do not. And if we leave those protections on the table, then I don't believe that we are fully fulfilling our oath. There is also there are also two pragmatic benefits of state constitutional primacy. First of all, we don't have to follow the zigzaggy jurisprudence of the federal courts. And if we decide a case under the state constitution on independent and adequate state grounds, that decision is final. It is not reviewable unless there is some sort of federal issue that can be raised. I believe that in one of the sleeper cases of the forthcoming US Supreme Court term, and I have been calling our US Supreme Court the Carpe Diem Court. I heard another adjective recently used that it is the YOLO Court. You only live once. They took a case from our court in which I believe that state constitutional interpretation will become more important than ever. It is a case that probably only a handful of people in this room have heard about. It's a case called State versus Cruz. And I don't mean to belittle the case when I say that it was a fairly routine criminal case. I would have put the odds that the court would grant cert in this case at far less than 1%, because it wasn't a particularly controversial issue. And the court granted review in this case, but it rewrote the question. Instead of the question, the substantive criminal law question on which the cert petition was based, it rewrote the question to ask whether the state procedural rule under which we decided the case was an independent and adequate state ground for that decision, meaning making it unreviewable in the US Supreme Court. While all of the rest of you are going to be watching the affirmative action cases and all of this, I'm going to be checking the docket every single day for State versus Cruz, because I think that this case may really be a harbinger for a court that I believe is probably more dedicated to federalism than any court, certainly in our lifetimes, and going back a really, really long way. So that's why I believe in primacy. The second is the serious examination principle. We have a number of early state Supreme Court decisions that say, for example, the Due Process Clause has similar language and similar purposes to the federal Constitution's Due Process Clause, and therefore we're going to interpret it the same. Well, I think that analysis is lacking, and especially where a provision is different than a provision in the US Constitution, regardless of what we may have said in an incredibly conclusory way in an early case, I think that we ought to examine the original meaning. After all, if you read Scalia and Garner and all of my colleagues do, and I suspect most of the judges in the state do when they're interpreting statutes or the Constitution, one of the bedrock rules is if language in two different provisions is different, you interpret them differently. You examine the nature of the difference and you credit that difference. And in fact, my colleagues and I have done that on many, many instances. So I think that is a bedrock provision, and very few of our provisions in our state constitution are identical to their federal counterparts. So we need to explore why. And that dovetails with the independent meaning principle, which is the third principle. The second one really focuses on how much deference we will give to past decisions that really were conclusory in their interpretation. The third principle, the independent meaning principle, is the principle that if the language is different, we should apply it differently. The fourth is what I call the originalist principle. So this brings us back to the subject matter of the conference here. Even if the language of the provisions is the same, we ought not simply hitch our jurisprudential wagon to whatever the federal courts are doing on that provision. So if we borrowed language from the US Supreme Court or from the original Constitution, and as interpreted by the Supreme Court, it would be the interpretation of that provision that existed in 1912 that ought to guide us. If we take any other approach, if we say, you know, this provision means whatever the US Supreme Court says it means because the language is similar or identical, what we're doing is we're authorizing the US Supreme Court to amend our Constitution, making it different than the original plain meaning that our framers articulated. And I looked once again before this talk at the provisions in our Constitution for amending the Constitution, and once again I did not find the provision saying the US Supreme Court can amend one of the provisions of our Constitution. Obviously it can change the meaning of the federal Constitution, and we must follow that. But what our Constitution means ought to be the original plain meaning in 1912. Just to give you one example of this, and this is one that I wish I had thought about as a litigator, but I had not thought all this through yet as a litigator. Due process, virtually identical, our provision to the US Constitution. So we begin with the presumption that it meant the same thing as it did in 1912. Were there any US Supreme Court decisions recent in 1912 that might have informed the framers' perspective? Anyone got a nomination? Oh my gosh, you were right. 7 years before our Constitution was adopted. Could that mean that our framers' conception of due process encompassed the Lochner decision? Maybe. Once again, I don't know, because we have not been presented with that argument. But possibly so, if my principles were to be applied. And then finally, the broader purpose principle. One of the things that we wish the legislature would do more often is to not make its purposes and intent a mystery to us, and to put it right in the legislation if they would, because it would be so much easier for statutory and constitutional interpretation. Well, the framers of our Constitution did exactly that. You know that the First Amendment, we often say, is the most important amendment because it's first, right? And it certainly was incredibly important to the framers: protection of freedom of speech, freedom of religion. If I were to ask you, what did the framers of our Constitution think was most important? You might look to Section 1 of our Declaration of Rights, and you might keep going to Section 2, and you'd be perhaps surprised to learn that Section 1 says, "A frequent recurrent to fundamental principles is essential to the security of individual rights and the perpetuity of free government." Framers were telling us the purpose of our Constitution, certainly the Declaration of Rights. Section 2, to make it even more explicit, titled Political Power, Purpose of Government. All political power is inherent in the people, and governments derive their just powers from the consent of the governed and are established to protect and maintain individual rights. Pretty nifty statement of purpose, and I think providing the broader purpose of the Constitution that, in a moment of ambiguity, ought to guide the decision-making of judges. Well, in my article, I conclude with the human ramifications for this. This is one of the geniuses of our Republican form of government, that we have not one source of protection of constitutional rights, but 51, at least 2 in every single state. And this was a lesson when I was at the Institute for Justice. This was a lesson taught to us largely by the left, which rediscovered state constitutions in the 1970s and the center-right did not really do so until the 1990s. So I want to finish by telling you about one case in which my colleagues and I did this at the Institute for Justice that I think illustrates the protective effect that a state constitution could have. I mentioned the Keynote case before. IJ litigated that case unsuccessfully in the US Supreme Court, but was at the same time litigating that issue in state courts. And the very first case, we knew that we were swimming upstream. There had already been a number of US Supreme Court decisions indicating that the public use provision of the Fifth Amendment was not going to be robust. So we knew we had an uphill battle, and when we chose our very first eminent domain case, we decided we needed the ultimate case with the ultimate villain and the ultimate unfair facts. And we found it in my home state of New Jersey. And, you know, not a huge amount of optimism about what the New Jersey courts might do in this situation, but nonetheless, happily, ultimately vindicated. So we found a case in Atlantic City where a hotel and casino developer decided that he needed a parking lot for his limousines. And he went to the people who owned that property, a very surly elderly widow named Vera Coking, a gold and silver shop, and a little Italian restaurant called Sabatini's. Anyone who is either from New Jersey or has been to New Jersey knows that we take our Italian restaurants really, really seriously. So the developer went to them and said, "I'd like to buy your property," and they said, "Not for sale." Mrs. Coking wanted to live the rest of her life in her house, and Sabatini's wanted to keep doing what it was doing. So notwithstanding what was happening in the US Supreme Court, we took this to court under the New Jersey Constitution, and despite the fact that the developer was, shall we say, one of the more difficult people we ever litigated against, we ended up winning. And under the New Jersey Constitution, this exercise of eminent domain was shut down. It turns out that that case had a happy ending, not just for us and our clients, but for everyone involved. Mrs. Coking got to live out the rest of her life in her home. Sabatini's continued selling wonderful Italian dinners for decades. And the developer was elected President of the United States. So my colleagues and I were able to say, we beat Donald J. Trump in court, which is not what a lot of people are able to say. So for those of you who are litigators, for those of you who are judges, for those of you who are scholars, this is freedom's frontier. This is close as we can get to virgin constitutional territory in this country. For students in the room, if you want a law review cited, be the first to write about a provision of our state constitution. For litigators, I cannot promise you that we will always agree with you, but it certainly is worthwhile to raise and independently litigate and develop state constitutional issues. I can assure you that those arguments will be carefully considered. But for anyone who believes in the preservation of our system of republicanism, federalism, and freedom, this is simply something that we need to know about and that we need to take very, very seriously. And I am so delighted to not only be a part of, but to sit back and listen to a program developed and presented on this very topic. Thank you all for being here today. Thank you.